Call now the second case on this morning's docket. It's case number 116545, State of Kansas v. Robert Ward. And while counsel is approaching, I might take this opportunity to indicate that Judge Ward is not sitting on this case, and he is being replaced by what I would consider our full-time appellate colleague this week. This is the Honorable Patrick McEnany, our senior judge. Judge McEnany will be appearing on almost all the other cases for this week as a regular justice. So, Judge McEnany, on behalf of our colleagues, I want to thank you for helping us out on this week's docket.
You're welcome.
Yeah. All right.
May it please the court, Mr. Ward appears through counsel, Casper Shire, Kansas Appellate Defender Office. Your Honor, could I please reserve 3 minutes for rebuttal?
3 minutes is granted.
Thank you, Your Honor. Back in 2013, Mr. Ward was convicted of criminal threat and misdemeanor assault. He was placed on probation for 12 months. In 2014, the district court, after an evidentiary hearing, found probation violations, sanctioned him, and extended his probation for an additional 12 months. Later in 2015, Mr. Ward stipulated to new probation violations and was remanded to serve his sentence in the Department of Corrections. He later filed a motion under KSA 1507, arguing, among other things, that his trial counsel at the original PV hearing was ineffective. The district court denied that motion summarily without an evidentiary hearing, determining that there were no issues of law or fact to require a hearing. He appealed that decision, and while that appeal was pending and before the parties had briefed the issue, he completed service of his prison sentence. The Court of Appeals dismissed the appeal as moot, citing State v. Montgomery, and this court granted the petition for review on the issue of mootness. Now, the central question that this case presents is whether or not the service of Mr. Ward's sentence renders his appeal moot when he challenged the underlying probation violations themselves, the finding that he actually violated his probation. And the Court of Appeals was right to look to Montgomery for guidance, but it was wrong in failing to note that this court is distinguishable from Montgomery on its facts. And in fact, it's distinguishable in a way that Montgomery itself recognized could be and should be important. In Montgomery, this court took up the case of a probationer who actually stipulated to his probation violations and challenged only the district court's imposition of his prison sentence as an abuse of the court's discretion. This court said that under those circumstances, the collateral consequences of the sanction that the court actually chose to impose, the imposition of the prison sentence, were not strong enough to overcome a mootness challenge once that sentence is served. However, in making that holding, the Montgomery court left the door open for a case like this. The Montgomery court noted that the primary prejudice that results from a probation violation is the district court's finding of violations itself, and not the sanction that the court actually chooses to impose. And that is exactly what Mr. Ward is challenging here.
How do you answer what the United States Supreme Court did in Spencer in when it determined that the collateral consequence is as a result of a future conviction, a future hearing in some way that this revocation might be used, that's too speculative to withstand a mootness challenge? That's basically what they said, and that's what's and why wouldn't we follow that?
Well, Your Honor, the Montgomery court took up specifically the Spencer case and looked at it, and the Montgomery court said two things about Spencer. One, that it was based on federal jurisprudence on mootness, and therefore those findings are not directly binding on this court. And second, it considered the very question that Spencer took up, and at least appeared to indicate that it might answer that question in a different way. after making the holding that if all we're talking about is the sanction itself that is imposed, the Spencer court did go out of its way to say, but had we been talking about the underlying probation violations here, that would be the primary prejudice that results. When a district court down the line is looking at a defendant at a sentencing hearing and trying to decide whether or not to grant that defendant probation, the district court is going to be much more interested in what they did to get their probation revoked than what the district court actually...
It's still very speculative. And the trouble I have with this, it really does assume that someone is not going to remain a law-abiding citizen and commit another crime, find themselves in front of the court in which a determination will have to be made regarding that probation revocation. It kind of assumes a lot, doesn't it? And assumes something I don't think we want to assume of the general public, that they're going to not be law-abiding citizens.
No, we don't. We certainly don't want to assume that. We want to assume that they will be. The reality of the situation, though, is that this could have consequences for some defendants down the line.
So it's just the could have
is
enough.
I think the could have is enough, Your Honor. I also think there are certain consequences. For example, eligibility for to have the conviction expunged from your record.
You mentioned, and I do want to address that briefly, you mentioned expungement and the ability to possess a firearm. You didn't raise that at the Court of Appeals. It was mentioned in one sentence in your
petition for review.
Is that anything we can really address? That's never been argued.
Well,
you just mention it. You don't even say how.
The mootness issue, of course, wasn't raised in the appellate briefing because there was no reason to raise the mootness issue at that point. I don't remember exactly what the language was that we used in the show cause was, to be perfectly honest with this court, but we did raise those issues in the petition for review.
I want to go back to your discussion about the speculation issue. In Montgomery, in our syllabus paragraph 4, or syllabus 4, we wrote, the non-statutory consequences arising from a probation revocation, which consequences will depend upon a judge's exercise of discretion in a future criminal proceeding, rather than upon the mere fact of the prior probation revocation, are insufficient to perpetuate a controversy for purposes of the mootness doctrine if the case has otherwise ceased. Didn't we decide, even though the facts of Montgomery didn't exactly fit this case through that syllabus paragraph, didn't we make a decision that is contrary to your argument?
I don't think so, Your Honor. And this is why. I'm not disputing the Montgomery holding, and I'm certainly not disputing at this point as it applies to a defendant who stipulates to probation violations. However, at the end of that Montgomery holding, there is language which I will concede is dicta, but there is language which suggests if there is a challenge to the actual violations themselves, that is the primary prejudice that comes out of a probation revocation hearing, and certainly leaves open the possibility that this case could be different. I would submit to the court that although that's dicta probably at this point, it's well-reasoned dicta and dicta that this court should make law, and this is the opportunity to do that. That's what we're asking this court to do.
Counsel, did I understand your argument is that you're not claiming that the district court abused its discretion in the sanction it imposed upon the finding of a probation violation, but rather the finding itself that he violated his probation? Is that correct?
That's correct, Your Honor.
That's confusing in view of the fact that he stipulated that he violated his probation as part of a plea agreement, and the court accepted his stipulation. How do you argue that he didn't violate probation when he's admitted in open court that he did?
At the second probation violation, he did stipulate to his violations. However, at the first probation violation, he did not. And there was an evidentiary hearing held on those violations. In fact, the case that served as the basis for the revocation, the original revocation in 2014, was ultimately dismissed by the state as part of a plea agreement, but also after it had gone to trial and resulted in a hung jury and a mistrial. And when Mr. Ward filed his 1507, what he was alleging was ineffective assistance of counsel at that original 2014 probation revocation hearing. So our argument is that everything goes back to that 2014 hearing. And Mr. Ward's argument raised in his 1507 that the district court would have lost jurisdiction over the case and been unable to remand him to the Department of Corrections in 2015 had it not revoked his probation in 2014, as far as I can tell, is legally sound.
If that's the case, in view of the amendment to 3504 that says that the court may correct an illegal sentence at any time while the defendant is serving the sentence, and that's retroactive, if you're allowed to go up on appeal or go back, if this is sent back for that argument, to consider that, it's really a futile argument unless a futile act to send it back, unless, of course, you're claiming that legislation is unconstitutional, isn't it?
I don't think so for two reasons, Your Honor. The first reason is Mr. Ward filed his claims at KSA 60-1507 motion. That's how the district court treated it. That's how the state treated it on appeal. That is how we treated it on appeal. It has been treated as a KSA 60-1507 motion. And KSA 60-1507 says that the court has jurisdiction as long as the motion is filed while the defendant is in custody. And in State v. Mundy, this court has said that the completion of custody, the release from custody, does not strip this court of the ability to adjudicate a claim under KSA 60-1507. So there is a separate vehicle besides the illegal sentencing statute to reach the merits of this claim.
But then what's the ultimate outcome of a finding that your client's counsel was ineffective in view of this statute? Are you seeking to set aside his sentence?
Not his sentence, Your Honor, no. Seeking to set aside the finding that he violated his probation in 2014.
Oh, I see. Okay. All right. I got you.
That is the ultimate relief that we're looking for here. And I recognize that there are a number of hurdles that we still have to go over before we get to that point, but this is an elephant that needs to be eaten one bite at a time, is our position.
I understand.
But
No,
go ahead.
Does expungement help your client, your argument that expunging, the possibility of the timeline expiring on expungement, when he was found guilty on of new charges and sentenced on those, would he still be barred from applying or from seeking expungement of all of his criminal sentences? Or, I mean, what effect would it have to expunge this one when there are other things that are still on his record?
Well, Your
And
Honor,
so does that change the argument as to your client at least?
I don't think it does, Your Honor. There's obviously one criminal conviction is substantially weightier than zero, but two is still weightier than one. It's something that affects his ability to get employment. The type of conviction may matter in certain circumstances, what he was convicted of in case 1 versus case 2. I think there are a number of reasons why expungement could still be helpful to him, even though he does have other convictions.
And then on the firearm, the other convictions could bar him, and they're really, does the same argument apply to the firearm conviction or the firearm application?
The firearm application is probably a trickier issue for us because any felony conviction, at least for a statutory period of time, prevents you from possessing a firearm. However, I think certainly the expungement issue is still a live issue, Your Honor.
The tricky part about both the expungement and the firearm is its completion of sentence dependent.
That's correct, Your Honor.
And the problem we have here, let's say you get your relief. That might impact a probation revocation in the future. That might be there, might not. But as it impacts expungement and firearm possession, how do you undo his release date from prison? How do you undo the completion of the sentence in the second subsequent plea? You can't undo that. You can't undo the release date. And even if you got the relief that, let's say, he shouldn't have served the 14 months as a result of the probation revocation, you really can't undo that either. You can't just say, well, he should have been out 14 months earlier. We don't know that. We don't know what the subsequent sentence would have been had it not been for that. The plea that was entered into was partly dependent on the stipulation to the probation violation in the 2012 case. We don't know what would have happened if that wasn't there. And so it's all so speculative, and you haven't outlined an argument for it at all. You just mentioned it. I mean, I'm just offering these questions as to the problems and hurdles that this case has.
And I see I'm out of time. Could I answer the question, Your Honor?
Certainly.
I think there is a path to relief in terms of defining an end date for this case, which is much earlier than...
And how is that? How can you say what that would be?
Well, in this case, Mr. Ward alleged ineffective assistance of counsel at the original PV hearing. If he's ultimately successful all the way down to that road, then the district court would have to conclude that there was no violation there and that his probation expired at the end of the original probation term. The court would then have lacked jurisdiction to revoke him at the second probation violation.
Stipulate to, right. So he shouldn't have served the remainder of those 14 months. But still, that's all.
But more importantly, as to this case, Your Honor, his probation would have terminated and the case would have been over 1 year from his original sentencing date, as opposed to when he ultimately got released from prison.
There's some irony there, because the collateral consequences kind of argument assumes violation of the law in the future. Whereas what you just said assumes no violation of law in addition to the one that he was already PV'd for, right?
But in this case, Your Honor, we don't have to assume. There were no additional probation violations alleged during the original term of probation.
Why allege more if he's already getting punished for the ones he was
Well, they
convicted but demonstrated to have engaged in?
They did ultimately allege more, Your Honor. That being the violations that he ultimately stipulated to. The issue with that is, had he not been violated the first time, his probation would have been over before those violations were ever alleged.
I understand that, but isn't there still a window of time between the originally alleged violations and the expiration of the probation term? And you're asking us to assume that in that window, you've nodded yes, so I'm going to continue. So assuming that window of time to exist, you are asking us to assume there would have been no violations in that period. That it would have expired naturally because there would have been no violations. Which to me is ironic because your other argument requires us to assume that there will be violations of the law in the future. I'm just pointing out the irony.
I understand, Your Honor. I see your point. I guess what I'm asking this court to assume is that had there been violations during that period, the court would have filed a motion to revoke. That they wouldn't sit on them and wait around for, I don't know, a new case to pop up or something along those lines.
Okay.
Any further questions? Thank you, counsel.
Thank you, Your Honor.
May it please the court, counsel. My name is Brandon Jones. I am the Franklin County Attorney, and I represent the state of Kansas in this case. There is just one issue before this court, and it's whether or not the Court of Appeals erred when it dismissed the appellant's appeal as moot. The state's position is that the Court of Appeals was correct in dismissing the appellant's appeal based upon this court's decision in State versus Montgomery. In this case, both the appellant and the state, there's no issue that the defendant in this case served both his underlying sentence in this case as well as the post-release. With that being said, based upon the holding in Montgomery, this case is moot and should not be heard by this court or any appellate court. The appellant, however, is arguing that this case is distinguishable from Montgomery because he argues that he did not stipulate to violate the terms of probation as in Montgomery did. He actually challenged the underlying grounds for revocation, and therefore he's not merely complaining about the disposition, but the actual finding of being in violation. The state's problem with that is you got to look at the procedural history of this case. The hearing he's complaining about being wrongfully decided is not the hearing which ultimately led to him serving his underlying sentence. That was the second revocation. In that case,
answer the question that he never had an opportunity to appeal. At least this is what his complaint is. The initial probation revocation, because he was not informed of his right to an appeal. He always objected to that finding. I guess there's correspondence to the court and then to counsel at the time of that revocation in which he contests it, and he never was given an opportunity to appeal that.
that's his contention.
That's his contention, right?
And that was going to be the state's argument, is that he cannot appeal the 2014, the original first revocation, because he didn't appeal it. He did not file a direct appeal. And so now he's trying to attack it on a 65th.
On a 1507, because he says he was never informed of his right to counsel. And I know it's a long road,
Right.
but it's a road that can be successful. Why shouldn't he have an opportunity to contest that original probation revocation?
And you say it can be successful, but the state's argument is it can't be, because 60-1507 subsection F imposes a 1-year statute or time limitation on filing a 60-1507. His original 60-1507 pro se filing was not filed until January 21st of 2016. That was over a year and a half after the first probation revocation, which occurred August 25th of 2014. So he was outside of the time when he filed his original pro se pleading to challenge under 60-1507 that first revocation. So therefore the state feels that...
Isn't he arguing an exception to that?
I would say yes, that's what he's trying to do, but I don't think he gets there. He's basically attempting to use the second revocation, in which he entered a plea agreement with the state, signed off on a 10-page plea agreement where he pled to a new aggravated battery, a new, more serious charge than the criminal threat and 2 misdemeanor assaults that were the basis of this case, along with got some charges dismissed in that aggravated battery case, and got another case dismissed as well, and the state agreed not to file a new case. So he got the benefit of the bargain of getting a couple cases dismissed, or case dismissed, several counts dismissed, and another case not charged for a plea agreement that ultimately he's complaining about. And then he after that tries to come back and attack a plea agreement that he entered in open court after signing a 10-page plea agreement, and a year and a half later tries to challenge the 2014 revocation. He's out of time. So that is the state's argument, essentially boiled down, is that it's moot because he served this underlying sentence, he served the post-release. What he's actually trying to challenge, if it's not moot, is a 2014 hearing in which he didn't file his 60-1507 till a year and a half later, out of time. And if he also filed it as a motion to correct a legal sentence, which the state does not feel that is. It was not an illegal sentence at all. But based upon the new statute, amendment to the statute, KSA 223504, he's only allowed to challenge that if he's serving the sentence, and he's not. So the state's position is he has no vehicle, no vessel to get back to what his actual complaint is, the 2014 revocation hearing. He's trying to use the 2015 one to breathe life into a dead, moot issue. And that's the state's position. Based upon all of that, the state feels that the Court of Appeals correctly decided this as being moot.
Does that conclude your presentation?
It does, Your Honor.
Do we have any further questions? Thank you, counsel.
Thank you.
I'd like to take just a moment to respond to the time bar argument. I think the important thing to note in this case is that the district court did not rule that that the motion was time barred. There may have been exceptions that Mr. Ward could have advocated for. We don't have factual findings on those because the district court never made the finding that it was time barred. I think before this court can conclude that the issue is time barred, it needs to, at the very least, go back. If the state hasn't waived that issue already, then it needs to go back to the district court so the district court can determine whether or not it's time barred. Apart from that, we would ask this court to reverse the Court of Appeals, to reinstate the appeal, and to remand to the Court of Appeals for a determination of the merits that have already been briefed by the parties.
I have one quick clarifying question. In order for you to prevail in this case, do you have to get to the second probation revocation hearing? Or is it sufficient just to get to the first one?
I want to make sure I'm understanding your question.
Well, let's say that things go really well for you. You win here, you go back, you successfully challenge ineffective assistance, and you get the 2014 revocation set aside or what have you. Is that all you need to prevail, or do you then have to go the extra step and get was it 2015 or what I'm thinking of as the
yes.
second probation revocation also set aside?
I think ultimately both need to be set aside, because if he prevails on the first one, then
That goes to my next question. What's the legal argument or underpinning of getting this? Assume you get the first probation revocation set aside. What's the theory for setting aside the second one?
the district court lacked jurisdiction.
Okay, so that's what I thought you were arguing, and that's where my question is. Is it true that that you could sort of post hoc strip, because certainly the district court had jurisdiction when it entered that revocation in 2015. How can you go back and take away jurisdiction that existed?
Because if you go back to the first probation revocation hearing in 2014, and if the district court were to make the finding that, in fact, there were no violations after a new hearing, then that probation term by law would have expired 1 year from his sentence, which is before the district court in 2015.
Is there any case that says that appellate determination of an error earlier in the process can somehow strip a later court of jurisdiction?
Not that I'm aware of, Your Honor. In this case, technically, I think it would be the district court making the finding that the original violations were not violations. If that were to happen, there would have to be a new evidentiary hearing at the district court level if he succeeds on the 1507. I think
Your claim is I know you're out of time, but just to nail this down, your claim is not that at the time the 2015 court lacked jurisdiction. That's not your claim. Am I correct in understanding that? It's that if we go through these steps of what ifs, then the district court might.
The district court.
We might take jurisdiction away after the fact.
Yes, Your Honor.
Okay.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Court will take this matter under advisement.